next matter is Melva Sherwood versus Lindsey Eberhardt. And I think all parties are present in the courtroom, so I'll give the counsel.
May I approach you?
You may. Again, each party, as you're aware, has 15 minutes in which to present the case. If you'd like to retain some of that time for rebuttal, let me know.
I would, Your Honor. I would like to reserve 5 minutes if I may.
Thank you. Again, we have ready briefs and we're ready to proceed with you.
Thank you. May it please the court. I'm James Barola. I represent Lindsey Eberhardt in this matter. There are several issues that are before the court in this specific appeal. As the court is aware, there's 7 appeals pending plus a writ of prohibition. As to this particular appeal, there are 5 main issues. Removal of Ms. Eberhardt's counsel pursuant to the witness advocate rule under 3.7A of the Rules of Professional Conduct. Removal for professional misconduct under 8.4 of Rules of Professional Misconduct. Alleged violations of Rules of Superintendence, Rule 48. Claims that myself, James Barola, was still the guardian ad litem in the matter. Trial court jurisdiction to even rule on the motion, and the issues of res judicata and collateral estoppel. I will address each of these. Each of these individual issues are simple on their face, but because each of these issues are intertwined, it makes this very confusing to anybody who's looking at it. And when you combine it with all the other appeals, procedurally it becomes quite burdensome. So I'm going to try to break it down as much as possible. As guardian ad litem, I was appointed in November of 2015. That matter concluded on September 7th, 2016, when I was removed as guardian ad litem by operation of law because the Sherwoods had dismissed their underlying custody matter. At that point in time, I was no longer a party to the action. I was no longer participating in any of the court proceedings except, as I will get to, the issue of GAL fees. When I was appointed guardian ad litem, I was appointed guardian ad litem only. I was not appointed attorney. Therefore, I did not have any competences. I didn't have any privilege. I was simply to investigate the alleged issues of unsuitability that the Sherwoods had brought before the trial court. I've been a guardian ad litem for upwards of 20 years. The role of guardian ad litem is to report to the court what is in the best interest of the children. It is not to investigate the unsuitability of a parent. Even in a children's services case, the Children's Services Agency would do the prosecuting of the allegations, and the guardian ad litem would go to disposition. What do we do if there is unsuitability?
But counsel, there are facts that you would be investigating that would maybe form premise of unsuitability.
There were, correct, Your Honor, there was allegations, but in essence, the court was asking Ms. Eberhardt to pay for an investigator to investigate whether she should have her children removed, which seems somewhat illogical and inconsistent. There's an agency by the state of Ohio, Lorain County Children's Services, that's job is to investigate if the children are neglected, dependent, or abused. So if the court believed that there was some merit or probable cause on the part of the Sherwood's allegations, they should have contacted Children's Services to investigate, not hired at $150 an hour a guardian ad litem to investigate whether children should be taken away from Ms. Eberhardt.
Did she file an objection to that? Or
She did not.
Opposed the appointment of the guardian ad litem?
She did not, Your Honor. She did raise that argument at the time of GAL fees, that she should never, GAL should never be appointed, but she did not raise it during the pendency of me as a guardian ad litem.
In the order appointing the guardian ad litem, was the fee, the hourly fee disclosed in that order? What was anticipated to be the charge?
Judge Janik doesn't require that in his order. He just simply appointed me as guardian ad litem. And it's not in the record, but I was approached by the magistrate and the 2 counsel at the time and asked if I would do it, and I disclosed at that time my rate, but it's not journalized anywhere.
The county doesn't have a specific rate that
They do not.
are.
No. They have a policy generally of a $1,000 deposit. Magistrate Nair found in his decision that $150 an hour is customary in the county, but there's no specific ruling regarding hourly rates. As I said, I conducted my investigation. At the time I raised the issues of grandparents' issues of doing things that might be problematic for the children. I've been in contact with the children's therapist, and I made the court aware through an ex parte motion asking to restrict some of the behaviors the grandparents were doing. At that point in time, I'd only met the Sherwoods once maybe, and had a couple phone calls. I think I may have spoken to Lindsey Eberhardt 2 times on the phone, maybe once or twice in person. So there wasn't a lot of extensive relationship with either side at that point in time, but there was clear violations of the children's rights. I mean, it was undisputed that grandmother wouldn't let him flush the toilet unless she was able to remove the excrement and break it apart in front of the children. She was weighing them naked, boys 7 and 8, every visit, following them. Every time they would come for a visit, they were being interrogated regarding their mother's activities. I made the court aware of that as early, before my initial report, in June of 2016.
As a guardian ad litem for the child, did you or do you not have the ability to file a motion with the court to terminate, or could you have done something more formally than just send a letter to the judge?
Well, I did, and I filed a motion to restrict the grandparents' visitation consistent with the therapist's direction. The therapist was concerned that the behaviors were having long-term psychological effect on the children, so I filed a motion and asked for all the restrictions, that they not follow them anymore, that they not interrogate them anymore, that they not go through their excrement anymore, that not, all the things that are listed, and the court granted it. And the therapist also believed that overnight visitation would not be in the children's best interest because the children would cry at night and there was fears of heights and some other things. So the court granted I did file a formal motion. That is what brought the litany of litigation and attacks upon me by the Sherwoods. There was 2 motions to remove me immediately upon my filing of that, and Mr. English is correct. I filed a response and I said there is no validity to anything that he is saying regarding my bias or behavior. I'm doing that which the therapist has told me and what had been admitted to by either Ms. Sherwood or the children had confided in me, and that I was doing my job. At that point in time, the Sherwoods stopped talking to me. They wouldn't take my phone calls. The therapist was calling me fairly regularly, telling me that allegation that grandmother sleeps with the youngest child on a regular basis and it makes him comfortable. He's glad that overnights aren't happening anymore, and I had to investigate that issue. But the Sherwood would talk to me. It was at that point in time that I wrote a letter to Judge Janning and indicated that Mr. English was correct, that they have created an adversarial relationship, that I will no longer to be able to act as guardian ad litem because it would, there's a potential conflict of interest because of the adversarial relationship. And I brought the letter, I hand-delivered it to Magistrate Nair, who read the first paragraph and said, I can't read this, give it to the judge's bailiff. So I brought it upstairs to Adam Breda, who's now a magistrate for the court, and he read the entire letter, and then he said, quote, Frank's not going to let you off this case, referring to Judge Janning. I said, well, how can I conduct an investigation when the other side's not even talking to me? How am I ever going to get paid in this case? And his comment was, document, document, document. Frank's not going to let you off this case. Stay to the end. And I went back to my office, and I made another phone call, and I continued the investigation, and I did a final report approximately 5 or 6 weeks later. At the conclusion of the matter, I was called as a witness. I wasn't paid to be the witness. I wasn't a guardian ad litem I had been removed on September 7th, but I was called as a witness by Wayne Nickel on behalf of Lindsey Eberhardt. I testified for 3 days where Mr. English cross-examined me extensively regarding every single thing I did on the case, where I was, why I did it, what my purpose for was doing it and my conclusions. And at the conclusion of that, I left. 3 weeks later, I submitted pursuant to court policy, within 30 days, you're supposed to submit your final bill. I did like 2-3 weeks later, submitted my final bill, and just waited to get my fees. Judge Jack had indicated he was going to issue his fee award in the visitation case when he made a decision. But on October 14th, when he issued the decision, he changed his mind and decided to schedule the matter for guardian ad litem fees before a magistrate there. So I had to participate in that. I was never, I wasn't acting as guardian ad litem any longer. The court, in my brief, it's indicated throughout that I have not been the guardian ad litem since September 7th. The court interchanges anytime they want. They call me the guardian ad litem. They say I'm violating Rule 48 a year after I've been the guardian ad litem. Nobody's ever raised any prohibition or any rule or any law that says that I can't have a social relationship with Lindsey Eberhardt.
You're just over 4.5 minutes left.
I'll reserve it.
May it please the court again, Brent English on behalf of the appellees in this case, Melva and Scott Sherwood. Virtually none of what Mr. Barilla has now attempted to offer as an excuse for his conduct in this case is part of the record. It is true that he filed a motion, Judge Schaefer, to an ex parte motion, despite the fact that he knew there was counsel on the other side, represented the Sherwoods. He filed an ex parte motion, which a trial court granted, a magistrate granted, and there was an immediate motion to set aside, and the court never heard that motion. But notwithstanding all of that, here is the issue. Mr. Barilla is correct that he was removed as guardian ad litem in on or about September 7th of 2016. However, the matter of guardian ad litem fees remained pending. There is no indication that the court was just going to decide this without having any kind of input from the parties. He did file a he prepared a so-called final billing statement, and everything that I've told you about in the last oral argument then transpired. The purported oral arguments in support of and in opposition to guardian ad litem fees, and ultimately the court granted some of the guardian ad litem fees, and that's the subject of the other appeal. So, Mr. Barilla, in the record in this case, you will see a motion for relief from judgment, and even though it's not specifically relevant to this appeal, it's highly relevant to rebut the arguments that Mr. Barilla has just advanced to the court. And in this motion for relief from judgment, we demonstrated with competent, credible evidence that Mr. Barilla began to act as Lindsey Eberhardt's lawyer. He filed objections on her behalf. He filed appellate briefs in this court on her behalf. Even though she signed them as pro se, they were unquestionably written by counsel. And we demonstrated how we learned of that fact. Nevertheless, Mr. Barilla was not a party to this case and not a party to any of the appeals except for, well, he wasn't a party to any appeal except for the issue on guardian ad litem fees. And he didn't file a brief, by the way, in opposition to our motion or to our appeal in regard to guardian ad litem fees. Nevertheless, in November of 2017, Lindsey Eberhardt filed purportedly pro se motions to show cause against the Sherwoods. They were not written in a way that you would suspect a pro se litigant would write them, but notwithstanding, we issued a notice of deposition for her to show up and testify about those facts. She did not appear. And we then filed a motion to compel discovery with respect to those motions and the discovery that we wanted in regard to those motions. And then Mr. Barilla pops up as suddenly her counsel on December 18th, 2017. And he enters an appearance for her and comes to the court several days later during a pretrial conference and announces that he should buy Melva Sherwood flowers for having introduced her to the love of his life. The question immediately became, can you serve as counsel in this case, since there is a pending motion for relief from judgment that pertains directly to Mr. Burilla's conduct and to Ms. Eberhardt's conduct? And can you represent her with respect to a contempt matter in light of these circumstances? The Court of Appeals, this court, on December 21st, remanded to the trial court its jurisdiction for 60 days so that the trial court could consider the motion for relief from judgment. So now that issue is squarely in front of the trial court. May Mr. Burilla represent one of the parties in the case if he himself is a party with respect to the motion for relief from judgment. It was my judgment that he could not, and I therefore filed a motion to disqualify him as counsel on the grounds that he unquestionably had to be a witness in the case, that you could not obtain this information from anyone else, and under Professional Rule of Conduct 3.7, he was a necessary witness and therefore should be disqualified. We also raised the issue that he had engaged in, regrettably, outrageous conduct, and that was prohibited by Professional Rule 8.4, and that the court should, in exercise of its discretion, not permit this kind of situation to continue. There was a hearing, which Mr. Burilla has never provided you with a transcript on his appeal. It occurred on January 30th, 2018, at which time Mr. Burilla made this claim that he had delivered this letter to the judge and informed him a long time ago of his alleged conflict in being the guardian ad litem. And the judge was incredulous, and frankly, so am I. Nevertheless, that's the claim he made. Mr. Burilla had a full opportunity to present why he was not conflicted out. The judge listened carefully. Both sides presented their arguments. Neither side requested an evidentiary hearing, per se. And on March 1st, the court disqualified Mr. Burilla, as well it should. It held that he was a necessary witness, and unquestionably he is and was. And it also held that his relationship with Lindsey Eberhardt was, let's just say, questionable, and as a result, he could not properly serve in a capacity of representing her and making representations for and about her while he was, in fact, her lover. This was an unseemly situation. And for that, Mr. Burilla has filed an appeal. And he contends this court didn't have jurisdiction. That's the same argument that we heard in the last argument. He also contends that he's not subject to any rules with respect to being a guardian ad litem. The fact of the matter is, he is. And he certainly was up until the time when he was disqualified as the guardian ad litem on June 7th. And he claims that collateral estoppel somehow applies in this case. Here's the argument. We filed a motion to disqualify him because of his bias and prejudice in the underlying case. The court, without knowing what the relationship was, and without knowing that he had admitted that he had this exact problem, which he now contends he told the court, which I submit is apocryphal at best, the court denied the motion to disqualify him as guardian ad litem. And as he has said today, he was never counsel for any party at that point, at least of record. Now he contends that since the court made a determination a long time ago with incomplete information that he was not disqualified as a guardian ad litem, the trial court was precluded under collateral estoppel from deciding whether or not he should be disqualified as counsel for one of the parties when we raised that issue. Collateral estoppel doesn't work that way. I respectfully submit, I briefed this matter carefully. It is clear collateral estoppel has zero relationship to this question. I know that it is a big deal to remove a lawyer as a party's counsel. And the court, there's a lot of case law saying it's a drastic measure. It's something that should not be done lightly, but ultimately, the standard of review is whether or not this is an abuse of discretion. And given the record as it is, and the fact that Mr. Barilla did not provide the court with the transcript of what was said to the court and how the court made its judgment, the findings of fact that the court concluded are entitled to deference. There is no contravening evidence whatsoever. And under these circumstances, given the facts as they are, I would respectfully submit that he is unquestionably a witness, and that the witness advocacy rule applies foursquare to his situation, and that he should not have been permitted to proceed as counsel, and in fact, the trial court did not err in any way in disqualifying him as counsel. I ask you to affirm. Thank you.
Thank you. You're just over 4 minutes.
Thank you. Mr. English is correct that this court remanded case numbers ending in 6-2 and 6-5 back to the trial court to consider the issue of the Sherwood 60B motion. That period of time, that 60 days, was December 21st, 2017 to February 19th, 2018. Judge Janik removed me as counsel for what Mr. English indicates because I was a necessary witness on March 1st. The trial court had lost jurisdiction to consider anything regarding the 60B motion, and that wasn't before the court. The only thing that was before the court regarding my representation of Ms. Eberhardt was the show cause. In the show cause motion, there was no indication by Mr. English other than a mention that my name was mentioned in the show cause, but there's no evidence or argument that I was going to be a necessary witness. I wasn't present when the Sherwoods allegedly violated the court order which led to the show cause motion. I wasn't, the necessary witnesses would have been the children who had their phone taken away from them by Ms. Sherwood, and their mother who was on the phone with them. I was at best a tangential witness, and the court even in their own decision says that I may be a witness in future proceedings if there's future show cause actions. They make no finding that I would be a witness in the pending show cause motion.
Counsel, let me go back to something that you started your oral argument with when you said that as a GAL that you had no interest in the proceedings and you were basically a fact finder and you didn't have there was no privilege related with any of the parties or anything. Wouldn't it be accurate, though, to say that when the court appointed a guardian ad litem, that the court expects cooperation?
Absolutely.
And something that you may not be willing to tell another person, you might open up and say to the guardian ad litem due to the fact that you want to make sure you're cooperative with the court's investigation.
That may be true, Your Honor, yes.
So let's put everything else aside. How in the world then can you serve as attorney for the opposing party after you've already had that basically, I want to say, a relationship with somebody that's, if not protected by law, is still of a confidential or fiduciary relationship?
I'd be happy to answer that. I would disagree that it's a fiduciary relationship. My duty is only to my wards and to the court. In this particular case, it was the Sherwoods that created an adversarial relationship that ended up me writing the letter.
Well, but that's common, isn't it?
It is common. The court ruled that is common. They weren't going to remove me for that reason.
But my point is, aside from your particular case, let's not get into the nitty-gritty of your particular case. The point is, people cooperate with guardian ad litem, or they're supposed to cooperate with guardian ad litem, so the truth can come out, so that the court can make an informed decision.
Right.
And how then can you turn around and be counsel for an opposing party after you basically operated as an impartial fact finder, supposedly?
I can address that, Your Honor. The order that is before the court was issued October 14, 2016, after I was removed as guardian ad litem. The judge's order regarding visitation had absolutely nothing to do with the custody case. It was regarding visitation only, and it was after my removal. The contempt motion, to which I entered an appearance to prosecute on behalf of Ms. Eberhardt, is consistent with my duties as a guardian ad litem for my wards, to protect them from the wrongdoing of the Sherwoods. I was prosecuting the enforcement of the violation of Judge Janik's October 14th order. There's nothing inconsistent with trying to protect my wards, as it essentially would be, I was hired by Ms. Eberhardt to be their lawyer and her lawyer to prosecute.
Well, that's what I was just gonna say, you weren't their attorney.
I wasn't previously.
Well, you were the guardian ad litem.
Correct.
You were not operating in an adversarial manner at that point, or you should not have been. And then, even if the mother had approached you to act or to hire you as attorney for the children, it still seems like there'd be a conflict of interest or the potential conflict of interest, or appearance of impropriety. How does the other side feel like they're getting any fair shake in regard to anything?
Well, I can't speak for how they feel, but certainly there's no rule or statute or case law that would indicate that there was a fiduciary duty or I owed any duty to the Sherwoods, and that their perception that
Well, you owed a duty of impartiality.
I did during the time I was impartial until September 7th. At that point in time, I'm no longer a party, I'm no longer under the governance of that case, and I'm an attorney practicing law. Whether that makes them feel uncomfortable isn't a basis to remove an attorney. I think the Supreme Court has addressed this issue, and my understanding is going forward, that if you're appointed guardian ad litem and you are an attorney, as a matter of course, you're going to be named as attorney and guardian ad litem. I think they've addressed this issue. It may have been a flaw in the previous makeup of guardian ad litems, but
What about excuse me, but I thought at one point, if there was, and it's my understanding then that the children never conflicted with what your recommendation was.
correct, there was never a conflict between my words.
So there was never any need to appoint you as an attorney for the children, or for you to have someone else appointed attorney for the children, because there was no conflict.
Correct.
So you would have stayed on simply as their guardian ad litem, not as an attorney, since there was no conflict.
Correct. Had I been their attorney, I would agree with this tribunal that I couldn't serve as Ms. Eberhardt's attorney later, because there would be an inherent conflict between her and her children. I wasn't appointed, so, I mean, this issue had been addressed with disciplinary counsel. There was no law or rule that I was violating.
If that's what you are.
Thank you, Your Honor.
Thank you. Thank you both for your presentations. The court will take the matter under advisement, issue a written decision, which we posted to our website and mail to both sides.
Thank you.